Justices of the Appellate Division Fourth Department. Hear ye, hear ye, hear ye. All persons. The Justices of the Appellate Division Fourth Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near and give their attendance, and they shall be heard.
Have a seat, everybody. Okay, the first case for argument this morning, People versus Thigpen. Morning.
Good morning. Good morning, Your Honors. May it please the court, Carrie Connor on behalf of the appellant Wesley Thigpen. The appeal waiver in this case was invalid and does not foreclose review of the statutory speedy trial issue in this case.
So how did those little marks get on the, that crossed out the certain parts of the waiver? No one's able to explain that. It's not discussed during any of the colloquies or whatever. Do we have a thought about that?
Your Honor, there's no explanation in the record. I think that also goes to one of my points that the court did not confirm with Mr. Thigpen whether he understood the written waiver before he signed it. The court, was able to review that document, and like in all appeal waiver cases where there's a written waiver, the court has access to this document. But no, there's no mention of that in the record. It's just that it is in the record and that it is on the written waiver.
And how should we construe that?
Well, I believe that written waiver really adds to the ambiguity of the oral and written waiver viewed in the totality. During the plea colloquy and the oral colloquy, Mr. Thigpen raised concerns about wanting a statutory speedy trial motion issued by his attorney, and his attorney left him with the impression that that was still something that he was considering doing. So that taken together with the written waiver where that is specifically crossed out, I think it leaves the impression that may still have been an option for him at that point.
Counselor, does it make a difference if he's asked, have you talked to your attorney about this waiver? And he says, absolutely, I have.
I think it would make a difference if there was not that direct mischaracterization between the oral colloquy and the written waiver when that is specifically crossed out, whereas during the oral colloquy, it was mentioned as something that he would not retain. I believe that just adds
But the
to the
cross out
confusion.
relates to perhaps a motion that was never made, though.
Correct, but during this same appearance, he mentioned that he wanted this raised. He was left with the impression by his attorney that he was still considering raising this motion. He asked the court about additional rights he would be sacrificing as a result of this waiver, and the court just said, I don't have control over the people's plea offers. That was not enough to really clarify this issue with Mr. Thigpen, and it just viewed in the totality between the two oral and written waivers, it really just, it's hard to know whether he really understood the consequences.
So let's assume that the waiver isn't effective because of this problem or other problem, where do we go from there?
Well, in this case, I believe that Mr. Thigpen asserted that he wanted these motions filed. His attorney even mentioned that that was something that he thought could be filed in this case. I believe that this court held in Sweet, the failure to bring a meritorious speedy trial motion is sufficient to render counsel ineffective. And in this case, I believe the issue is clear cut enough to make that determination.
Okay.
So I can go through just very briefly the timeline as far as speedy trial.
If you'd like.
Sure. So in this case, the action commenced with the filing of the felony complaints on November 13th, 2020. Mr. Thigpen was not indicted until January 3rd of 2022. And there was no statement of readiness during that time period.
Right, but there were some things that were going on in the world during that time period, wasn't there?
Correct. This was during the pandemic, but the attorneys and the court were not without guidance as far as excludable time. The executive orders outline exactly the amount of time that would be deducted. And in this case, even just that time period between commencement and the filing of the indictment that was 272 days with the COVID exclusion. Not to mention that there was no statement of readiness until well after the lapse of time, which occurred on March 10th of 2022.
Let me interrupt you for a second. There was something that bothered the defendant in this case, and I was going to ask you about that. Okay, so it appears that this judge has some kind of a calendaring preference, that she gives dates for pleas to occur, and then after that, she makes a motion cutoff date. In other words, before the motions are heard, there's this plea cutoff. And the defendant actually seemed like he was pretty up on, let's see, criminal procedure, let's put it that way. And he took her to task on this. There's a lot in the record about why are you doing it this way? I sort of wondered about that as well.
Right. Yes. I wonder about that as well. I mean, I don't really have an explanation for why the court had that preference, but I do think it, again, impacted whether or not these motions were filed at all. And also just the pressure of having the plea cutoff date impacted his ability to maybe fully get the relief he wanted in this case.
Okay.
But yes, just overall, I believe that the pre-readiness delays, like I said, caused by the delay in arraignment, which is the case here, or court congestion, they do not excuse the people from declaring their readiness. So I believe that this should be reversed and the indictment should be dismissed.
Thank you, counsel.
Thank you, Your Honors.
Mr. Zickel, do you know how that those words got crossed out?
I don't. I didn't handle this case at the trial level. And there was no, as Your Honor has mentioned, there was no reference to it at all made in the record, either by the defendant, defense attorney, prosecutor, or the court. So we don't know by whom it was made, when it was made, what its import, what it's supposed to indicate, if anything. I think it's just as likely that it was some sort of stray mark that was made on it, perhaps to emphasize the fact that the defendant was waiving his 30-30 rights by his waiver of appeal. So again, it's just impossible for this court to evaluate what that mark means.
So
but
let me ask you this.
We do know that the defendant engaged in a very detailed colloquy with the court, where the court said, you're going to waive everything except A, B, C, and D. And so in that way, the defendant certainly was made aware that his waiver would, that is his waiver of appeal, would waive the issue of any 30-30 issue that he otherwise might have waived. I cut you off. I apologize.
Oh, well, let's just move on from what I was thinking, because I had additional thoughts. Okay, so how clear, counsel for defendant says it was a clear-cut motion. It was something that would have been granted if made. Can I have your thoughts on that?
Yes. First of all, as the court has noted, there was something very significant going on in the world and in the court system at the time this case was commenced. That's, of course, is the pandemic and the COVID pause that went on during that time. That is something which certainly would have been litigated because it does relate to excludable time. There are many other things that can relate to excludable time. Waivers, certain other issues having to do with the courts. If there had been a motion made, a 30-30 motion, there would have been a detailed record setting forth all the time frames that we're talking about: commencement, statement of readiness, and excludable time that went into that. We don't have that here. And there is nothing, you can't just look at a calendar, as I submit that counsel tried to do when making her argument that this is a clear-cut case. You can't just look at the calendar because there's a lot that can go on during that time, which would render time periods excludable, that is not chargeable to the people.
Okay. Anything you'd like to add?
The 30-30 issue is not something, as has already been indicated to the court. It's not something that snuck up on the defendant. It was clearly an issue that he had on his mind at the time the case came on for a proceeding that led to his plea. And he had the chance to discuss that with his attorney. And in the end, he said, okay, look, I want to save my kids the terrifying ordeal of having to do this trial. Therefore, I want to enter this plea. Knowing full well that that was a motion that could be made if he chose not to. And in fact, he weighed it after consultation with counsel and chose not to make.
Well, we don't know what the subject of that conversation with counsel was, correct? So that would be the subject of 440.
We don't know what that conversation was, but we know that the opportunity for the conversation was there because that issue was clearly, out there, on the record, on the defendant's mind. And then he was given an opportunity to consult with counsel, and the result of that conversation, whatever may the content have been, was the entry of the plea.
Okay.
I don't know, I can't say about the timing of the motion calendar. The court usually schedules a motion calendar upon arraignment. And then if it goes beyond, if the case goes beyond that calendar, then the court will call the parties in and say, what's going on here? And I think that's what happened here. We haven't received motions. Why haven't we received motions? What is going on? So.
Okay.
Thank you.
Thank you, Counselor. Okay, the next case on our calendar, People versus Harrison, number 486. Okay, Mr. Schifrin will be on the camera.
Good morning. Can you hear me, Your Honors?
We sure can.
Thank you. Brian Schifrin on behalf of Jermaine Harrison. In point one, we urge that it was a reversible error for the court to refuse to admit the prior sworn statement of Ms. Vascalero when she gave critical testimony at trial inconsistent with that statement. The only two witnesses who testified what happened at the fight, which resulted in Mr. Thayer being stabbed, there was Ms. Vascalero and Mr. Thayer. They both testified that they didn't see Mr. Harrison with a knife or engaged in stabbing motions. Instead, they both testified he was fighting with his fist balled up. He was punching. The people's theory was it was after Ms. Vascalero walked away from the fight. She testified for about 10 seconds that there was a scream, and at that point, their theory was Mr. Harrison stabbed Mr. Thayer. On cross-examination, after she testified that no, I didn't see bleeding during the fall, Mr. Thayer during the fight, the counsel read out loud 3 sentences from the 27-sentence sworn statement that she had given to the police. At that point, she said, I don't recall that. She was then given the full statement to read, with the court directing her to review it to herself. So the jury never heard the rest of the statement. The rest of the statement, which the jury didn't hear, includes her swearing that after the part that the jury heard, seeing him bleeding, they were still fighting. She walked away, she heard a scream, turned around, and saw Mr. Rogers, Mr. Thayer's cousin, carrying Mr. Thayer. That sequence of events makes clear that the bleeding described in the statement was prior to her walking away. Again, never heard by the jury. On redirect examination, Ms. Vascalero went further than she did on cross. She said, what she said in this one statement was that the only bleeding that she saw was after she turned around. When that testimony was given, because it was so inconsistent with what's in this one statement and the sequence, and because it was such important testimony, because if the stabbing occurred during a fight when Mr. Harrison's hands were balled up in fists and he didn't have a knife, he wasn't the stabber. On redirect, Mr. Harrison's attorney sought the admission of that prior inconsistent statement, because when a witness denies a prior inconsistent statement, the statement is admissible.
Mr. Sifrin, excuse me. Didn't defense counsel have the opportunity during the trial and did so cross-examine this witness with her statement verbatim? He read from the statement and questioned her on cross-examination. So there's cases, the Piazza case and the Lewis cases, which indicate that in those instances, it's not necessary to admit the prior inconsistent written statement because the jury has had an opportunity to hear what those inconsistencies were, and defense counsel had adequate and sufficient opportunity to cross-examine that particular witness with respect to those prior inconsistent statements.
Piazza and Lewis are clearly distinguishable because in both those cases, the full prior inconsistent statement was available and before the jury. In this case, again, after the first only 3 sentences of the 27-sentence statement were read the court directed Ms. Vascalero to read the rest of the statement to herself. The rest of that statement was not before the jury, and that's critical because the critical latter.
Well, the relevant portions were with respect to what I saw before. What I turned, did I turn? Did I see something? There was a light. I walked away.
That was not none of that, Your Honor. If that was before the jury, I wouldn't be here. The transcript makes clear the language that I turned was after the part that was read aloud. The jury never heard the sentence that begins with the words. Then I took off to get my car. They were still fighting at that point. When I was halfway to my car, I heard screaming. I turned around. I saw Joseph's cousin Jared carrying him. That was never before the jury. And the reason it wasn't before the jury wasn't because I'm a competent counsel. It was because as is often the case with prior statements, the witness was directed to read it to herself. That's why it was so critical to have the jury have this admitted so the jury could see it, and it's different than Piazza. Also, Piazza and Lewis are different, and Piazza is different because in Piazza, the witness acknowledged, yep, I gave an inconsistent statement, but that statement was false. What I'm testifying today is true. What happened here, by contrast, Ms. Vascalero testified that this prior statement was consistent, that all I said was that the bleeding was viewed by me after I turned around, which is, if you read the full statement, which a jury never had, it's clear, she still bleeding. They continued fighting. She's upset because they weren't stopping fighting. She walks away. She had testimony for 10 seconds. She hears a scream and then turns around and she's being held, Thayer's being held by his cousin, Mr. Rogers. That sequence makes clear the bleeding she described was prior to her walking around, and that occurred at a time that Mr. Harrison could not have had a knife because he was fighting with his fist balled up. The other argument made in the DA's brief as to why it was an error was claimed as a Bornhold error, given the fact there was extensive questioning about the statement, okay, and when the bleeding occurred. Questioning that both before and after she read the statement, including page 252, after reading the full statement, she again denied seeing him bleed during the fight, that there was no Bornhold violation, which is why there was no Bornhold objection, and that wasn't the basis of the ruling. What happened below is when the defense attorney correctly sought the admission of a prior inconsistent statement because they are admissible under People versus Duncan, People versus Booker, when the DA said, prior inconsistent statements are only used for impeachment. They're not admissible. And the court said, I agree. That wasn't Bornhold. That was a misunderstanding of the law. The law is when there's a prior inconsistent statement about a material fact, and nothing is more material as to when the bleeding occurred, because, again, if it occurred earlier, it wasn't Mr. Harrison who did the stabbing, that was error to exclude it. This wasn't harmless. No one ever saw him with a knife or stabbing. No knife was ever found associated with him. There was no blood found on him. There was no admissions. This was the key to the case, and it was error to exclude it. In point 2, we urge that there was denial of the right to the effective assistance of counsel by counsel's failure to request a missing witness charge with respect to Jared Rogers, the cousin of Mr. Thayer, who was on the people's witness list and was present at the fight. The DA's brief says there's utterly no support in the record for the contention that he witnessed the fight. That's simply wrong. Both Mr. Thayer and Ms. Vascalero testified that the 3 of them, Rogers, Thayer, and Velasquez, left Tommy's bar together, encountered Harrison, and the altercation began. And she testified when she walked away 10 seconds, she turned around, she saw Mr. Thayer being picked up by his cousin. Well, if she walked 10 seconds away and he was being picked up, he was right there. And her sworn statement, which is in the record, at page 852, says she turned around, he was carrying her. It was Roger was already carrying Thayer. Clearly, he was at the fight. The people's next argument, after arguing he wasn't present, was this would have been cumulative. The testimony is cumulative if it would not have contradicted or added to existing testimony, as People versus Smith, given that no witness testified to having observed Mr. Harrison with a knife, let alone stab Mr. Thayer. And Ms. Vescalero was not even facing Mr. Thayer when the people contend he was stabbed. It cannot be said the testimony of Mr. Rogers, who again, the cousin of Mr. Thayer, who was present at the fight, would not have added to their testimony. Thus, Mr. Harrison was entitled to an adverse inference charge. The most effective way to challenge a people's case was if the defense attorney in summation pointed out that Thayer's cousin, Mr. Rogers, was there, why didn't they call him? And then the jury receiving a missing witness charge where they're told they could draw an adverse inference from the failure to call Mr. Thayer as a witness. Again, this is a case that relied on stabbing occurring after she walked away, because it could not have occurred earlier by Mr. Harrison being the stabber. For all these reasons, we urge reversal is required.
Thank you, Mr. Schifrin.
Morning, Your Honors. Michael Tantillo for the respondent. Turning to point one first, it's really been black letter law in this state for almost 50 years, ever since People versus Piazza was decided by the Court of Appeals, that where a defendant has a full opportunity to explore a witness's purportedly inconsistent statement on cross-examination, the trial court has discretion to either admit or decline admission of the written statement. And that's exactly what happened here. Defense counsel spent a good portion of time on cross with the witness. I think between cross and recross, something like 5 or 6 pages exclusively on the statement that she gave. So, you know, he's had that opportunity fully to develop what he wanted to during the course of her testimony. The fact that defense counsel didn't read the entire statement to the jury is irrelevant, because there was a great portion of the rest of the statement that was 100% consistent with her trial testimony. So it's obviously understandable why he would not read those portions to the jury. I also submit, and this is in regard to both point 1 and 2, that even though we strenuously deny the allegations of error in the ruling here, the error, if it was hypothetically there, had to be harmless. Because the evidence in this case is uncontradicted that there were only 2 people involved in this fight, the defendant and the victim. The evidence was uncontradicted that the victim was unarmed. The evidence was uncontradicted that after the victim had been struck in the abdomen by the defendant, he couldn't breathe, went to the ground, and realized he'd been stabbed and bleeding. And that was corroborated later on by medical testimony of 4 separate stab wounds. And in addition to also, and I recognize that the courts indicate this is not tremendously weighty, but the defendant also lied later on, stating that he had not been there, gave a false name, false date of birth, all evincing a consciousness of guilt. Regarding the point 2, regarding the allegation that there should have been a missing witness instruction, once again, it's very clear under People versus Gonzalez from the Court of Appeals and its progeny that it is incumbent upon the defendant to establish what the witness knew and to establish that that testimony would have been non-cumulative. In this case, there was no basis for that to have been done, because nobody bothered questioning Jared Rogers about where he was or what he had been. Contrary, or what he had seen.
There was no written statement from him.
There was no written statement whatsoever.
No one had an idea what he was going to say.
No, the only evidence in the record was 2 points. Contrary to what the defendant alleged, it was not established in the evidence that he was present. It was not established that he saw what happened. The only testimony in the entire trial is 2 points. 1, he left the bar with the victim and the victim's girlfriend. And 2, at some unspecified point later on, after the stabbing, he helped get the victim up to off the ground and into a car. That was it. This court has held in People versus Safus that speculation on what a witness might have said is inadequate for a defendant to meet his burden to and warrant a missing witness instruction. Again, I argue harmless error for the second point as well.
Thank you, Counselor.
Thank you very much.
Okay, case number 487, People versus Lyons. Morning, Counselor.
Good morning, Your Honors. I am going to focus my argument solely on point two. It is my client's position that the Sirwa hearing and the resultant order of that hearing was erroneous. The people allege that he tried to intimidate a main witness in this case by threatening to kill her through another witness. That witness, or through another person, Mr. Barber. That person happened to be in the same cell block as my client and received paperwork from his lawyer indicating that this witness was on the people's list to testify. Up until that point, she's been under protective order. And the people's evidence was severely lacking as far as what the standard is here to comply with Sirwa and the cases that come out of it. The standard is highly probable or clear and convincing evidence that the defendant intimidated or used somebody else to intimidate a witness out of testifying. Here, all we have is a temporal proximity. He received his court papers with the witness's name at about 10 in the morning. About 11:45, a call was made from one of my client's cell block mates to this witness. And in that conversation, there's nothing indicating that Mr. Lyons put Mr. Barber up to intimidating this witness from testifying.
The court in its decision pointed to a chain of events, correct?
A chain of events, but yes, Your Honor. But those chain events are still lacking, I think. There was nothing in this conversation other than, I guess for lack of a better word, selfishness as to why Mr. Barber didn't want this witness to testify. You know, and his biggest reason was that everybody in the block knew that she was on Mr. Lyons' paperwork and that he would be considered a rat and potentially be hurt. There's nothing in there saying, like, you know, don't testify. Go ahead, Your Honor.
No, but the chain of events were more, I mean, wasn't the testimony that she was afraid of him to begin with, and then it was exacerbated after the, you know, subpoena?
She said she was afraid, but she never really provided why she was afraid.
Did she have an order of protection? Did she have an order of protection against this individual? And as soon as it was over, it expired, and shortly thereafter, once she appears on the witness list, within hours, all of a sudden the friend's calling her up.
That's exactly
Was it a social call? How you doing? You know, and how's the baby doing? You know, my good friend, my right-hand man. You know,
But that's not enough, Your Honor. I don't think that's enough. I mean,
it's not enough. Okay, and how many times did he call? I mean,
he called once, according to this, but everything he said in the conversation, we can't just go by
and there's repeated times he called the day of test. She was supposed to testify, right?
Yeah, but I mean, that was well after the hearing. I mean, I'm talking about the evidence at the Sirwa hearing.
Testify, and he's calling her that day, you know, I mean.
Yeah, but it's Barber is calling her. I mean, again, this is all just from, they had a relationship, Barber and this witness. There was domestic violence. I mean, the police testified.
Must have been an interesting relationship then, if he's you know, committing domestic violence and abusing her.
Well, Barber, not my client. Yeah, yes, Your Honor.
Right, but the court just clearly made an inference based on this chain of events, the so-called threats, the order of protection, and then she doesn't show up to testify. When the indication was she was gonna show up to testify. So what do you say about that?
Your Honor said inference, and inference just isn't enough. I mean, you got to have some kind of tangible evidence, and I know it's circumstantial. I mean, very rarely are you going to have the case where the defendant.
You can have an inference and still be, and the standard's clear and convincing in this particular hearing. Correct?
Yes, you can have an inference, but the inference isn't good enough here. There's nothing that points to my client putting Mr. Barber on the spot to call her and stop her from testifying. Again, we have to go by what the conversation was and what was recorded in the jail. What was recorded in the jails is him saying that I'm going to get killed. Him being mad at her for being a rat. Him being mad at her because everybody else in the cell block's going to think he's a rat. I don't think that's enough. There's no mention whatsoever once of my client's name in the Sirwa hearing. Nothing. I mean, this is inference can, yes, it can be proven inference, but not these inferences, Your Honor.
Mr. Ganesh, you don't find the proximity of that call troubling?
Not at all, because what the proximity says is that's when he got the paperwork and everybody in the block knew about it. I mean, no, I don't, because the only thing the proximity reveals here is that he got the paperwork and he was probably upset that he saw that she was testifying. It doesn't mean that all of a sudden he put somebody else up to call her and get her from testifying. I mean, the proximity is that's when he got their paperwork. Everybody else on the block knew what was going on after he got the paperwork. I think that's the only fair inference from that. You can't infer from that.
You're speculating on that everyone else on the block knew this. This is common knowledge. It's how the information is transmitted. I mean, it's just.
But I'm not speculating.
Everyone knows.
It's not speculating, Your Honor. I mean, the testimony showed that they're all in the same project.
Anyone else saying they know?
Well, no, but they didn't have any.
Well, that's speculating, aren't you? Up here today.
It's an inference, and there's no difference in the inference the court used here to say that he.
So the court can't use that inference, but you can use that inference.
It's not an inference, though, Your Honor. There was testimony saying that they were all together.
Okay, anything further?
No, Your Honor.
Thank you.
Good morning, Your Honors. May it please the court, Laura Jordan on behalf of the Niagara County District Attorney's Office. I would submit that there was clear and convincing evidence that this witness was functionally unavailable due to the defendant's actions in this case. There was testimony and defendant's attorney indicated that he went to the jail on December 8th, turned over the grand jury testimony as well as the other documents to his client. Within a very short time period after that, almost immediately, Keon Barber gets on the phone with Miss McDougal and starts telling her that you're not going to come to court. Your name is all over my man's paperwork. They were cell block mates, but they were certainly much more than that. There was testimony from Detective Battalato that there was an extensive history between these two, friendship that went back years. They often, when they were incarcerated together, used each other's PIN numbers and they had to make phone calls. So this was much more than two people that were just on the cell together or on the block together.
Is the import of what was said on those phone calls really up for discussion? It was pretty direct.
It was, Your Honor. I would submit it was. And also, I would point out to the court that the calls that occurred on December 12th as well, which is the date that this witness was set to testify, those calls were discussed within the hearing. The people submitted their motion on December 12th, which is the same day that she was supposed to testify. This was during the trial. They held the hearing the following day on December 13th, and those additional calls were discussed. Again, I'm sure the court has seen the testimony. There was an extensive history between Mr. Barber and Miss McDougal, a history of intimidation. Her mother's car was shot up just the year before, purportedly by Barber. And those phone calls were made to her on the 12th as well as to her father. And there was a history there as well of Mr. Barber intimidating Miss McDougal in the past as well as her family. I think the nexus is clearly there between when this paperwork was turned over, what the subject of those conversations were, and the fact that it was intended to keep Miss McDougal from coming to court.
Okay, anything else?
Nothing further, Your Honor.
Okay, thank you,
Thank you.
counsel. Okay, case number 488, People versus Cash Bynum. Morning.
Good morning, Your Honors. May it please the court, Krista Markarian for Mr. Bynum. I will be focusing on point 1 of my brief. The police in this case did not have probable cause to arrest Mr. Bynum. When looking at the language in the BOLO, it specifically stated, if located, please detain, do not question or Mirandize. In this case, Mr. Bynum was immediately arrested by the...
I'm sorry to interrupt you, but at the language, because I did look at the language, there's a little more there. It says the arrest paperwork is on file at E-District.
Yes, Your Honor. The arrest paperwork being on file does not mean anything as the probable cause. At the suppression hearing, the officer testified that BOLO is not an arrest warrant. It does not automatically.
Wait, what officer? You got to be careful what officer we're talking about. That may be Ortiz that said that, but.
It was Officer Lenhart at the hearing that testified that the BOLO was not automatically an arrest warrant.
No, Goodspeed indicated, I believe, that Goodspeed had the BOLO. In fact, if we look at the body cam footage, he had the actual paper copy of the BOLO.
Yes, and that was not produced until Mr. Bynum was already arrested in the patrol vehicle.
But his indication from that BOLO was, if arrest paperwork is on file, we have probable cause to make an arrest.
I would disagree with that, Your Honor, especially as this arrest is under the fellow officer rule.
Right.
So these officers, the lieutenant and Lenhart, neither of them were involved in the investigation of this burglary. It all hinges on the information possessed by Ortiz.
To be clear, right, we have to be careful which officer knows what.
Yes.
Right, because they can impart information. So we're talking about the information that Lenhart and Goodspeed have on the scene, which comes from the BOLO alone. And then what information Ortiz had when he prepared the BOLO will be heard.
Yes, and I would submit that because Lenhart and Goodspeed, they only had the BOLO. And I think the language in that BOLO is clear. Even though there is arrest paperwork on file, they agree that that is not enough to equate to an arrest warrant. And I think it all has to come from Ortiz. He is the only person investigating this burglary. He is the only detective assigned, and his information was incredibly minimal. All we have is an inconsistent 911 call. This burglary occurred 10 days ago. These officers on scene testify at the suppression hearing. They don't know what was taken. They're speculating, was this a domestic? Then they realize it's not. They don't have any of the information. I would submit merely stating that there's arrest paperwork on file is insufficient, especially given Ortiz's testimony that he indicated, I would not have probable cause until after I spoke with him. And even after he spoke with Mr. Bynum, he still wasn't arrested for the burglary. And I would submit that his information under the fellow officer rule was not enough for probable cause, and that's why the search should fall in its entirety. As to the issues with, and that as a result too, these officers, they did not know what was taken. They indicated they really did not know anything. They have this sheet of paper, but also the seizure in this case occurs immediately of Mr. Bynum. He's immediately arrested, put back in the patrol car. That is it. And then I think as the situation continues to evolve, that if there is probable cause, that the search should still fail. If you look at the body worn camera, which is so important in this case, it shows the events leading up to the search is incredibly problematic. You have the officers standing outside of the vehicle saying, kind of speculating. At first they're saying, how can they get in? There's an initial conversation asking, can we look through it? And the other officer comments saying, he doesn't think the car had anything to do.
They have a discussion out there.
Yes.
All right, but that's not necessarily, I mean, just because they may have had a discussion, there may have been some comments about what should we do? Because I think one officer says, can you see anything in there? Is there anything in open view? That may not be the reason why they actually did the search on site. Because, I mean, Lenhart testified, I may have this wrong. We decided to tow the vehicle. Once we decided to tow the vehicle, then I directed the search.
The officers, Lenhart's testimony, he indicates they didn't decide to tow the vehicle until after they found the firearm. And that's also reflected in the body worn cameras. The tow's not even called until after the firearm was found. So they weren't even, I would submit that the decision made to tow the vehicle was not until after the firearm was discovered. I would also in this case, I think it's important to see the officers standing outside the vehicle because they're trying to figure out how can we get into this car and search it. And then
well, you're inferring that a little bit. I mean, they're there, they've taken the only driver away. They've got an empty car apparently parked in front of a bus stop. And the question is, what do we do? Do we have to secure this vehicle?
And I think the concern is it wasn't to secure the vehicle. There was no testimony that the car was parked in front of a bus stop at the suppression hearing. The officers also, they did not say that on the vehicle tow report, this car was searched incident to arrest. It was not searched because there was a threat, because the manual for the Buffalo Police indicates that the car has to be unsecured and that there's a threat that it would be damaged. That testimony was not presented. There's no testimony that it was illegally parked or in front of the bus stop. None of the officers indicated that. And none of the officers, there's a very specific procedure that must be followed for it to be, if it was held for evidence. And none of those steps were followed, none of those forms. It's taken to a special impound lot. That procedure wasn't done. And the manual actually discourages, it says vehicles shall not be towed instant to arrest. And it talks about it being searched unless there's like an evidentiary reason, which was not at the scene. Instead, the officers, I think it's important to show them standing outside the car, because finally you have the lieutenant come over and say, let's search it for an inventory search. And all of the officers dive into the vehicle with flashlights. That's important, as under this court is held in People v. Cunningham, they're not following their policy. Their policy requires that they have their vehicle inventory sheet and they're filling it out as they go. None of the officers in that body worn camera has a vehicle tow report. And even when they fill it out, which it's not shown on body worn camera, which it's not showing that report is ever filled out.
We have a fairly recent case, Brundage, essentially the direction from like, we're not here to micromanage the actual process. And aren't we getting close to that? If we look at the body cam footage and we have to see what officer, did they have the check, the clipboard and who was doing it, how many officers were in the car? It gets a little, is that what you're asking us to do here?
No, Your Honor, I'm not asking. I think this case is very distinct from People v. Brundage, because I think it's for two reasons. I think this case falls exactly in the scope of this court's recent decision in People v. Cunningham, where I think the policy is clear. When you're doing a vehicle tow report, you can't have one search where you're just searching the vehicle and then go in afterwards and do the vehicle tow report. That you can't have these two separate searches. You have to have, you're searching this car for an inventory search. You're doing it to protect the police department against an illegal search. I mean, not illegal search, but you're doing it to protect against for the property. And that's not what was done here. We have the officers looking in the vehicle. We also have the testimony from Goodspeed saying that he's looking for common places, that he searched the area that he searched. It's a common place for guns, drugs, things of that nature. We have that concerning testimony. When you couple that with them not following their own policy when doing the vehicle tow report, it shows that this was an invalid inventory search from its inception. And I think that also the officers didn't even write the disposition as to when any of these items go. And further, in not following and doing this discretionary search, an inventory search, you're not going to be searching underneath the center console of the center of the car. That, and as the officer is trying to speculate that this could technically be a container, is exactly what inventory searches aim to prohibit. They're trying to call anything in a container so that they can search it is a complete violation of their discretion, which is what this court upheld in People v. Cunningham. And further, if the officers, they didn't even know what was taken in this case. So this can't even be a search pursuant to the automobile exception. And knowing that, and in Goodspeed's testimony as well, he's trying to say like even like the stuffing of the inside of a seat, that could be a container. And that's a complete violation of an officer's discretion pursuant to an inventory search. So I think when viewing that this court's holding in Cunningham with the body worn camera that shows this unfettered search, that shows that the tow was called after the firearm was found, that they had to go underneath the plastic covering of the center console to retrieve this. This wasn't if this wasn't inventory search, it wasn't valid. It was also a pretextual search for contraband as well.
Thank you very much, counsel.
Thank you.
Good morning. May it please the court, April Orlowski for the people. With respect to counsel's last point, this case is very distinguishable from Brundage, and it's not distinguishable from Brundage. It's very distinguishable from Cunningham, because in the Cunningham case, and I think this is important here, the officers had a clear idea they were looking for the defendant. They had an indication that he had a gun. This is not the case at all in our case. The officers in our case had a bolo out for him.
If we could just talk about the bolo, because defense counsel says it's a bit, at the very least, ambiguous, because it indicates, detain him, don't question or Mirandize, but at the same time, it indicates there's arrest paperwork on file. Does that bolo, the language in that bolo to the receiving officer, does it give the receiving officer probable cause based on this language alone?
I think it does, Your Honor, and I think the reason for that is the fellow officer rule.
We know the fellow officer rules at play here, but what these, if the officers were to read this bolo, does it indicate that they are to make the arrest upon approaching this defendant?
I think it could be a little choppy because it says don't arrest, but the rest of work.
No, it doesn't say don't arrest.
It says do not Mirandize.
Please detain.
Yes. And the issue is detain meaning arrest, or, is detain meaning, are we putting him in the back seat and just transferring him for questioning? I understand how that can be tricky, and you can see that it's tricky even within the officer's testimony, because the officers state during their testimony that they construe that as an arrest.
To be clear, the receiving officers, or at least Goodspeed, who has the document on scene, he reads this bulletin as providing probable cause for an arrest.
Yes.
He interprets that language. And then I think Lenhart says, we put him in the car, the defendant in the car, in order to bring him to the station because there was arrest paperwork. We had to connect him with the arrest paperwork.
Yes. And I think that's something perhaps the BPD can do a little better job of when issuing these things. But for this case in particular, I think that there was probable cause, because what happened with Detective Ortiz, not the on-scene officers, is when Detective Ortiz, initially the 911 caller did not provide the name of the burglar. However, after Detective Ortiz had spoken with the victim of the burglar, she did indicate his name and that he was her neighbor. She
says, I got robbed and I know who robbed me, and it was this defendant.
Yes, and she said she did.
And you say that's probable cause.
Well, yes, and Your Honor, the reason
the detective, this is the problem. The detective testifies, well, maybe that wasn't probable cause. I needed to speak to the defendant first.
That's what he said, Your Honor, but with respect to probable cause Fourth Amendment analysis, the subjective beliefs of don't really play a role in that. So he might have subjectively believed he didn't have probable cause, but he did in fact have probable cause to put, because probable cause isn't objective proof, or it doesn't mean we have to have cause to convict him at a trial. He had to just have a reasonable belief that an offense had been or was being committed. And he had that given that the victim gave defendant's specific name and the fact that he was her neighbor and he was in her apartment. So he had that. You might have.
It is a little, frankly, it is a little bizarre though that this defendant wasn't charged with burglary. He wasn't presented to the grand jury, and that was the reason why he was picked up and brought to the station.
That is true. And I think the reason for that, again, this is speculation on my part, was that they found him with a gun. And at that point, the burglary was a far less dramatic crime that they had him on. And this is an individual who's carrying around a loaded firearm. And that's a much bigger problem in the community. And with respect to the valid search here, which we believe was completely appropriate, the issue that the defense contends is that it was incorrectly done and incorrectly decided upon. Officer Lenhart testified that he made the decision to tow the defendant's vehicle because, quote, if there is nobody else there to take the vehicle, we have to safeguard the vehicle. It's uncontested. The defendant was the only person in this vehicle.
What about the policy that you don't tow incidents of arrest?
That it doesn't happen when they can't leave the vehicle on the street, because there was no testimony about this being in the view of the bus stop, but there are pictures showing that it's in the view of the bus stop. You can't just leave an unattended.
That's right. There's no testimony in relationship to the bus stop at all. So the officer saying, that how does that justify taking the vehicle when it's just incident to an arrest.
Because they can't just leave a vehicle on the street in an area that's, and this is in their policy, that is subject to potential, could get the vehicle stolen, can get vehicle damaged, can get the vehicle.
Did he call his girlfriend or whatever?
He didn't do that.
Come pick it up, which should they allowed him to do that.
Well, the problem
I'll dial-
was,
I'll dial
I'm sorry,
the
Your
phone
Honor.
for you.
They did let him call the girlfriend. The problem is that the girlfriend didn't arrive on the scene when the defendant was taken away. And the Court of Appeals has held, and this department has followed, that police officers are not required to make alternative arrangements prior to impounding the vehicle. So that they're not determined to, or not required to see if the defendant can get anyone else there to remove the car. And the problem here was the defendant's girlfriend was an unlicensed driver. So she had to call her father to arrange to get her father to come get her to then Uber back. And it was a process. So she just couldn't be there by the time the defendant was taken away.
About the fact that they didn't have the inventory log at the time they all rushed in to take an inventory of the vehicle. I mean, you look at the video and there's 3 or 4 officers rummaging through the vehicle right now, and no one has an inventory search as counsel indicated.
There was a P31 completed by Officer McCarthy, and it lists the items in the vehicle, specifically the firearm, the 2 cell phones, a foldable chair, and water bottles. To the extent that the dispo section on that form was not completed, I submit this is a situation where minor inconsistencies in the vehicle report are not sufficient to invalidate it, such as the situation in
Things on
People
the
Believe.
totality of the circumstances, all these minor problems as they accumulate, that's okay.
Yeah, this is not a situation where, they tow a car and 3 hours later they do a vehicle they decide to get around to the vehicle report. It was done, maybe not pen in hand while they're searching, but it was done, several minutes later, not several hours later, and they write down the items in there. Do they put dispo results in there? I mean, we clearly know the gun's in the lab, so that's, even though we don't have a dispo written down, we certainly know what happened to that firearm.
But you don't see a problem where the firearm was found?
I think what can happen there.
Beyond the manual of the Buffalo Police Department?
The manual requires that that they search through the contents of the vehicle, opening and inspecting any and all containers.
Right,
I
and
think
this wasn't a container.
it wasn't a container, it's like a bag in the vehicle. But I think what is important here is they were looking for items of the burglary, and you could certainly find, like, they didn't know what was taken, so they could be looking for items of silverware, and you could certainly shove silverware down there.
Oh, well, right, they had to undo the underneath, it wasn't in a glove compartment or anything like.
That is true.
Disassemble part of the car to find these.
I think disassembled is not the right word, Your Honor. I think
Okay, tell me the right word.
pulled up a carpet. And I think that the term that the witness used, pulled out the carpet so that made it sound like there was an extensive amount of damage here, is not in fact what happened.
Well, Counselor, if I could, the gun was located, if I understand the testimony from Goodspeed, as he ran his fingers across, he felt the barrel of the gun.
Mhm.
Because the gun had been tucked in underneath the console. In order to remove the gun that had been tucked under, then the carpet had been pulled back.
He pulled up the rug.
Right, but the gun was discovered by running fingers across.
Yes.
The area.
But to get it, you had to pull the rug up. They didn't pluck the rug out
Right.
or, break anything. And if you look at the picture,
He was looking for contraband, right? That's what he said.
He did say
I'm
that.
looking for contraband. I'm not doing an inventory search. I'm looking for
he
contraband.
did say that, but I think that might not have been the best word for him to use, but contraband means, anything that's illegal. So
Well, he says
proceeds.
he's familiar with, that's where contraband is hidden.
Mhm.
So I'm looking for contraband. I'm not doing an inventory search here. I may have a form here. I'm gonna write down, two cell phones and a water bottle, of course they're gonna.
I can't deny he testified to that, and that wasn't the greatest word I could have put in his mouth. But I think what he's implying here is he was looking for articles of that burglary, which would have been illegal for the defendant to have, which is the definition of contraband. He wasn't solely searching for a gun here. He was searching for proceeds of the burglary, which to a police lieutenant would have been contraband. This is a situation where the gun was found as the consequence of an inventory search, not the sole purpose of an inventory
Just to
search.
follow up to Justice Greenwood's questioning then with respect to is what's not a container though?
I would say, so for example, if
Going
you,
back or lifting up carpeting to get underneath the council, that's a container?
can I say that's not a broad definition of a container? No. But can I say that's not a valid inventory search? Absolutely not. That's a valid inventory search.
Okay, counsel, anything more?
No, Your Honors, thank you.
No, thank you. Case number 493, People versus Riley.
Yeah. Sorry, folks.
Counsel?
Good morning. May it please the court, Aaron Friedman on behalf of Adriel Riley Jr. Your Honors, rather than go point by point, I'm going to start with a big picture of the case, move to the applicable legal standards, and then discuss the facts. So I want to start by acknowledging that this case is horrific and heartbreaking, and none of the arguments that I make today are intended to undermine or make light of that in any way. But I don't believe that Adriel, who was a 14-year-old child at the time of this incident, intended to kill Mr. Ammenhauser. More importantly, I don't believe that the people proved that he did, and had his attorney introduced into evidence at trial information that appears elsewhere in the record at trial, that the lack of that specific intent would be that much more apparent. So from that idea, I structured my brief to bring a number of arguments to give this court an option in terms of potential remedies that would be most appropriate. If the verdict is against the weight, then this court must dismiss the indictment. If it is also insufficient, then it can find Adriel guilty of the lesser included offense of manslaughter. That's, of course, under the Cooney and Heatley cases, or grant him a new trial where he can get his constitutional right to counsel to make the arguments about why he lacks the specific intent.
Do you want to stick with intent for a moment, counsel?
Yes.
So, look, as I read your brief, I understand your argument is even if the proof establishes that he doused the victim with lighter fluid and lit him on fire, that even that proof wouldn't establish intent to kill, because the people would have to somehow rule out that the dousing of an individual with lighter fluid and letting him on fire could have been designed to seriously injure or harass or threaten or somehow intimidate, not kill. Is that your position?
My frontline position, Your Honor, is that because this is a circumstantial case, we don't know what it is that we.
No, I understand that. But setting someone on fire, I think, is your position, that setting someone on fire, intentionally setting someone on fire, can never amount to intent to kill unless you've got direct evidence.
I don't believe that's true. But here we have a 14-year-old child who, again, there's evidence elsewhere in the record, he struggles with consequential thinking.
That slips into your other argument.
That's correct.
That slips into your other
That's
argument. But let's set aside the 14-year-old, let's set aside the infancy factor.
I think if there's video of an adult doing that, so if you're not relying on circumstantial evidence, if it's on camera, one person does it, I think you could get intent from an adult.
Infer the intent.
In
The
that
natural probable cause of setting someone on fire by putting an accelerant on them and setting them on fire is your intent to kill them.
That's correct, but I think that requires two things. First, that infancy isn't an issue, and secondly, that we understand the conduct. And the issue here, I believe, what distinguishes this is we don't know what it is that Adriel did versus what his co-defendant Xavier did. And so that is not, I mean, it's possible that Adriel may have only put a little bit of the lighter fluid
on Mr. Ammenhauser's pant leg, and then the co-defendant did the rest. That's possible. It's possible that Adriel said, hey, put a little on his pant leg to scare him, and he did more. We don't know. So I think I'll return to the legal standards maybe after discussing the facts, and we can continue this colloquy. But there's really 4 buckets of evidence. First is that Adriel and Xavier are on video. It looks like they might be making a rap video. And I think this cuts against intent for 2 reasons. First, this is right before the incident. It doesn't look like they're malicious. It doesn't look like they're angry. These are, 2 kids acting like knuckleheads, but it looks like they're smiling, they're enjoying themselves.
With a shotgun.
With a shotgun, which I think also cuts against murder, because if your intent is to kill someone and you have a shotgun here, there is at least a natural inference that you would use the shotgun to kill them if that was your intent. So I think it actually cuts against it, but it does establish that they're in the apartment, the 2 of them. And then from there, we have the forensic evidence.
He does natural things with guns, but not with setting people on fire. He's too young to understand what the consequences of a fire is, but he's smart enough to know with a gun that's probable. That's what he should be doing if he wants to kill somebody. Is that what you're arguing?
I think that's true. I think that with a gun, I mean, well, it depends where you shoot someone, but certainly you shoot someone in the chest, you shoot someone in the head. There's much more of an inference then, in that case, than what will happen with the fire. So the next bucket of evidence that I was going to discuss is the forensic evidence, and I think it's important to show where there is and isn't lighter fluid. There's lighter fluid on a blanket, which allows for the inference that maybe they wanted to scare him. They thought he'd shed off the blanket. They didn't know that the lighter fluid would seep to the clothes. And again, I'm using the word they because we don't know who did what. And then the other extremely relevant piece of information is that Mr. Ammenhauser was wearing a red hat, and this hat has no lighter fluid on it whatsoever. And again, had there been lighter fluid on the hat, that would, I think, lead more naturally to the inference that intending for this man to die was the specific intent.
That's your position here, that in order to show intent to kill by use of lighter fluid in a match, you have to douse that victim in the head or in the chest, or not on a blanket. There's got to be more direct evidence as to where that accelerant was applied to the victim. That's your position?
I think there's a number of ways of reaching that conclusion. My position is only what is here is not enough. I think the hat adds to that inference.
But clearly the court had to reach that. The court drew that inference.
Correct.
And that's the question that's in front of us here. Was that a natural, normal inference to be drawn from this evidence here, including the which you're walking us through right now?
So I think this, Your Honor, maybe moves us naturally to a discussion of the applicable legal standards. So for a weight of the evidence review, that's a bit more straightforward. The Court of Appeals recently held in Bakke that the question is, does the evidence exclude beyond a reasonable doubt? Now, under the sufficiency analysis, the people cite Hines and Williams for the standard being whether there's a valid line of reasoning and permissible inferences. But these cases have to be read alongside the Court of Appeals 2014 case of People v. Reed, which asks if there's a rational basis for excluding the innocent explanations. And I think you can actually harmonize these cases and say, well, there is a permissible line of reasoning and permissible inferences when there's a rational reason to exclude the innocent possibilities. But in both cases, really, it can't be surmise and conjecture. And I don't believe, viewing this evidence, that there's a rational way of jumping from one to the other. So moving to the next 2 buckets of evidence are all after the fact, essentially statements that tend to evince a consciousness of guilt of various types. But I don't believe that any of these goes to murder exclusively at the exclusion of manslaughter. That these statements about not wanting to get in trouble, lying to the police, giving a false name, a false version of the events. I mean, to the extent that Adriel is only trying to protect himself versus himself and his co-defendant, his friends, I think that they go towards both. And we know there's a number of crimes at play here. We know that Adriel has an open warrant. They have a shotgun in the house. There's some conversation about drug use. There was an arson charge. They set a fire. You have maybe assault, maybe manslaughter. And when all of these statements are made, Mr. Ammenhauser is still alive. So, I mean, Adriel doesn't find out that that Mr. Ammenhauser's dead until sometime in the course of these proceedings. I mean, you look at the statement he makes while he's in the police precinct that he thinks he's going to go because his mother's there. You know, I think there's enough to conclude that he did something wrong, and I'm not disputing that in any way. I just don't think there's enough to say that what he did was murder intentionally, that he intended to kill this man.
What about his conduct when the people are trying to put out the fire and what he was observed, doing and saying?
Yeah, so Your Honor, I think reading the transcript, I think that people make entirely too much of Adriel and Xavian not rendering aid. In the first instance, we don't know if they tried to render any aid.
But it was more than just not rendering aid. It was threats that he made to the victim and trying to tell him certain things to say and not say.
Right. So I think that the things that he intended him to say are to not get in trouble, tell them that the white guy did it. I mean, whether or not it's a threat, this is what the witnesses said, that they found it to be communicated in a threatening manner. But say the white guy did it, in my mind, that at least allows for the possibility that Adriel believes he's going to survive. He's going to stay alive. He's going to talk to police. He doesn't want to get caught. And so because of that, he's saying, here, tell the police this. The idea that he's giving him his dying declaration, that assumes that Adriel knows that he's going to die. I don't think that you can make that assumption based on the record information. And again, in terms of not rendering aid, there's all of these other people here on the scene. So what 14-year-old child and a 16-year-old can do that these other people aren't doing, entirely unclear. What is clear is that they don't hinder that aid in any way. They don't physically obstruct. There's no restraints in the chair inside the apartment. Nothing like that whatsoever.
That might have been where the shotgun came in too. We don't know. I mean, in terms of they had a shotgun and the back door was blocked. Counselor, if I could ask you, I'm going back to intent, if I might. I don't know if you're familiar with a case that we released in April, People v. Brent, involving a situation where the defendant there, from our case, doused his girlfriend with gasoline and set her on fire. Are you not familiar with that case?
I'm not, Your Honor. My apologies. But from that description alone, it sounds like the conduct is clear. I mean, when we think of intent.
Well, the issue in that case, you're not familiar with it, but once you get past the issue of identity, was it the defendant that did the dousing? The question of what is the natural and likely consequence of setting someone on fire if you doused them with lighter fluid was what was before us in that particular case. Wait, since you haven't looked at it.
But Your Honor, I would again distinguish just on these two bases that I mean, if that was an adult in that case, I think it's very relevant that we're talking about a 14-year-old child. And again, there's more information that goes to the ineffective assistance claim. The quote that he struggles with consequential thinking, he struggles with cause and effect thinking, he's impulsive. That's not in the trial record. I think that it very much should be. But when we think about intent inferred through conduct, we need to know what the conduct is. So it seems in that case, the intent, the conduct is clear, and the conduct is clear enough to get to intent. But here you don't have the conduct clear whatsoever because there are the two children inside the apartment. So again, it seems from his behavior afterwards that he's guilty for doing something, that he knows he did something wrong that he shouldn't have done. But I don't know how you get to one versus the other just based on what's here in this record. And Your Honors, before I sit, I'd like to just briefly mention adultification. Adultification is where society is more likely to view Black children as older than their white counterparts. It's been widely recognized.
This in the record someplace?
This isn't in the record.
Okay, then be brief.
I've just a sentence or two, Your Honor, if I may. Adultification has been widely recognized in the social sciences literature. 6 state courts have discussed it, and I believe that that's what the district attorney is engaging in adultification, finding a Black child more guilty, more culpable, less innocent, when she says that when she refers to Adriel as pure evil, something to that effect. I think it's shocking to use those words when describing a child, and I think that the trial court sitting as finder of fact may have also had an implicit bias as well.
Thank you, Counselor.
Good morning, Your Honors. Aaron Schwaller for the people. While this case is primarily circumstantial, I think what it's important to underweight in legal sufficiency to highlight is we have effectively an admission. We have defendant talking to co-defendant through a wall stating, this is what I told to the police. This is what I told to the investigators. You need to corroborate my story, essentially. We could do 30 years for this, I believe he said. And if I'm too street to fold.
That defense counsel says that's true. All those statements indicate that he was up to no good in this apartment.
Mhm.
And he understood that,
Mhm.
but it didn't mean he intended to kill the victim. So how do you go from those statements where we may be in trouble if we're pinned with something in this apartment to he intended to kill Mr. Ammenhouse?
I think if you take those statements, we can do 30 years for this. He might be 14, he might be 15, 16, 17. It doesn't really matter. He knows the level of culpability that he faces.
He's doing that. He's looking at the sentencing guidelines in his head and he's measuring that up. That's the conversation that's going between the wall. I think
it's the totality of the circumstances. If you take that and you take, the fact that someone in that apartment, there were 3 people in this apartment, the victim, the defendant, and the co-defendant. He was doused with gasoline, lit on fire. They rendered no aid. They lied about their age, or specifically, defendant lied about his name. There was, and then he knelt down by the victim and said, who did this. You need to tell them who did this. It was a white crackhead, I believe he said, which necessarily excludes defendant because he was African American. That to me evinces his intent. He knew
intent to do what?
To kill him.
The conversation he has with the victim establishes that he wanted to kill the victim. That's your position.
Not just that specific conversation.
Isn't it the real issue here is the dousing with gasoline and lighting someone on fire?
Sure.
That's as I read your brief. That alone is like pointing a gun at someone and pulling the trigger.
Right.
Whether he's 14 or 24.
Sure.
If you put lighter fluid on someone and put a match to that person, you intend to kill.
Yes.
Period. That's what you're asking us to conclude.
I believe so. I think that's reasonable.
Just to be clear.
I think that's certainly a permissible inference to make based on weight or legal sufficiency.
Right. Now, what about the fact that he's 14?
Mhm.
I mean, defense counsel, his position is that it was ineffective to not raise those issues before the trial court.
I mean, my position would be, well, first of all, this is a single issue. So under ineffective assistance, if that's what we're talking about, this would be a single issue thing. And essentially in some substance, that would be, he failed to raise his infancy. In my view, based on the overwhelming evidence, I don't think that would be a position that would be likely to succeed. And for that reason, I don't think that would account to ineffective assistance. And unless your honors have anything else, very briefly on harsh and severe, I know he was 14 years old and I know he got the max, which was 15 to life, but I mean, he had violent priors. He brought a gun to school. He sold drugs. He assaulted staff at a children's center and he lit someone on fire and watched him die. I don't think the max is severe.
Thank you, counsel.
Thanks.
The next case for argument is case number 494, Oneida County Department of Social Services, and Marcus R. I understand both counsel will be virtual. Okay, I think you're both on. Mr. Tessiman, I think you're up first.
Yes, Your Honor, afraid I cannot see anything there.
We can see you.
Can you hear me?
We can hear you. We can see you. Okay.
All right. Very good. If it may please the court, Francis Tessiman for Marcus R. Your Honors, my argument, as you can tell from the brief, is primarily because I believe that there are two very important divisions in regarding to the statute with regard to the termination of parental rights. On the one hand, if someone is suffering from a mental illness, they're not capable of taking care of the child. If they're not suffering from a mental illness, terminating their rights based upon failure to plan basically says that they don't care about this child. They're not doing what they can, but they are capable of doing this. I believe here that right from the beginning of this case, the court noted that Marcus R. was suffering from mental illnesses. This, and then the agency proceeded solely on the grounds of the fact that, or of a contention that he failed to plan. And throughout the entire proceedings, it was constantly noted that he did not, was not, I'm sorry, Your Honor, I was having just a little video issue here. That
Okay,
now,
so
at the time of trial, there was testimony from the social worker that he had been compliant with services, that he had improved significantly, that he had progressed with his visit, that he had housing, and he was expecting the furniture to be able to take care of this child. Granted, Mr. Randall had severe issues with regard to his relationships with the other adults. There is nothing in the record that indicates that he ever really had any interaction with the child or any problems with the child. But there's certainly reason to believe that this matter should have proceeded under the mental health provisions, which would have required the petitioners and the court to appoint a psychiatrist or psychologist to evaluate him and to determine whether or not he was capable of taking care of this child. I believe that the result of this is also important in the future of the child. And I believe that the child is a prime concern in this. I was always constantly reminded by Judge Kevin Carter when I appeared from that we have to have concern for the child. This child will grow up with a notion that his father was neglectful, did not care enough to plan, enough to provide for the child. When in fact, I think that the thrust of this was that he was unable to do this. We don't know that for a fact because the court did not appoint a psychologist in this case.
well, Mr. Testament, we know from the record that Mr. R was being treated for mental illness. He was supposed to be taking medications for that mental illness, and I think we know from the record that he wasn't always compliant with doing that.
No, but we do not know what the medication was or what the effects of the medication were or whether the medication was in fact able to make any difference in this situation. Furthermore, it occurred to me that there has never been anything that definitively indicates as to who has the burden of proof that a person is financially and physically able to care for the child. Or is that just an assumption? I don't see that in any decisions. And that, in a sense, troubles me because we now know that many mental illnesses are as a result of physical conditions within the human body. We know, for instance, ADHD, which is one of the conditions that Mr. R had, is caused by insufficient supplies of dopamine and the interplay of serotonin in the body. And there are many other conditions that we are now learning how the chemistry and the function of the brain, which is certainly a physical part of our body, affects our ability to process information
I have one more question for you, Mr. Testament. This, what you're bringing up right now, he should have been dealt with under a different part of the statute that deals with mental illness and not his inability to care for the child. Was any of this raised or discussed at all below, in family court?
I don't believe it directly as such or not, but much of the thrust of all of the comments of the judge, of the petitioner's counsel and respondent's counsel had to deal with the Mr. R's mental health.
Okay. Well, thank you very much.
The,
I think we understand.
okay, thank you very much.
Okay. Ms. Giorgio?
Good morning, Your Honors. May it please the court, Stephanie DiGiorgio, attorney for the child. I'll keep it brief. The record is sufficient that the child was permanently neglected. I think, if you look at the record on its totality, although mental health was a big issue and it was focused on, there's a number of factors that support that the child was neglected. Sir did not have the appropriate housing. It was very clear he was incarcerated from the time, I'm not sure if at the time the child was born, but once the child was in foster care, he was still incarcerated. He couch surfed, he was bouncing around, he was homeless. By the time he got an appropriate house, it still didn't have the necessary furnishings and things that were required for the child. He didn't engage with the parent services, which was discussed with him while he was incarcerated, that he should engage upon his release. He had numerous, outbursts, which I connect not just to the mental health, but he had violations of the order of protection against the mother. So I believe that there was a number of factors that the court considered, not just his mental health. Again, it was a primary focus, but I think there was a number of things that the court utilized to say that the child was permanently neglected. And I know it wasn't really focused on, but he only had, in the length of time that this case went on, minimal in-person contact with this child. I mean, the child is now 4 years old. At the time of this, child would have been young, and I understand that, engaging with a child is difficult at that age. But certainly, 15 minutes biweekly on a telephone call, and then jumping to getting the child back to being in his care is a pretty significant jump. So unless the court has any specific questions, I'll rest on my papers.
Thank you, counsel.
Thank you.
Yep.
Okay, next case, number 495. Matter of Veronica Webb versus Christopher Couts. My understanding, we will have one appearance and that will be virtually. Okay, Ms. Lorenz, you're the only person arguing today.
Well, thank you. I guess I'll keep it brief. As indicated in my, well, first, Jennifer Lorenz, attorney for the child. As indicated in my brief, there were several factors that constituted a change in circumstances, excessive corporal punishment, the express wishes of an older child. My client was 12 at the time. The father's lack of and failure to ensure proper medical and medical care for the child. I think the record had indicated that in the 4 years or so, the child had never gone to the pediatrician. She had never gone to the dentist. And based on those factors, the court properly determined that it was in the child's best interest to reside primarily with her mother. And unless the court has any questions, I will rest on my brief.
Counsel, thank you very much.
Thank you.
Okay, next for argument, case number 496, Kessler versus Carr.
Good morning, Your Honors. Jonathan Gorski from Dulce Panapeno on behalf of Plaintiff Appellant Emily Kessler. I know it's not my place today to ask questions, but I want to start my argument by asking a question, a rhetorical one, of course. Where in the record is there any evidence whatsoever that Ms. Kessler did not sustain a serious injury to her cervical spine under the significant limitation of use category? The only medical evidence in this record is the defense IME report of Dr. John Letty and the physician affirmation.
Mr. Gorski, this is your cross motion, right? You're appealing the denial of your cross motion, correct?
That is correct, Your Honor.
So in these instances where it's your motion, we have to give the non-moving party some benefits, correct? Inferences and they're in play, correct?
I would agree with that, Your Honor. But the way that the question arrives at this court.
Let me finish mine first. And I know you asked a question first and foremost, and maybe you'll answer a few of mine too. So it's good to see you again though. So Dr. Capicano is a lot relying upon the defendant Letty's IME. And the IME reviewed the past medical records. Many times we see instances where medical records aren't reviewed. And I think there were various instances where the plaintiff in this instance had prior incidents where there were attentions to her spine, whether or not there was a fall or there were, get my notes correct, she went to a chiropractor in 2015 for her neck pain and low back pain and headaches. In 2016, there's an ATV rollover, and she had cervical dysfunction, headaches, and muscle strains. In 19 and 20, she had a fall, which were treatment for neck stiffness and frequent headaches. So Dr. Letty reviewed all these records in his opinion, and he indicated that this was a minor temporary cervical strain injury that had resolved in his mind. And the range of motion limitations, which and many times in cases that we've seen here and have argued before, where there are range of motion limitations, that's evidence of objective proof that there's an injury here. But as Dr. Letty indicated, those range of motions were subjective complaints of pain. And his post-MRI, or looking at the post-MRI, showed no objective evidence of any traumatic injury causally related to the MRI, the motor vehicle accident. So what, in your cross motion, you're relying upon is those opinions by Dr. Letty. And he's indicating that those range of motions were subjective. And then in this instance, Capicano gave a different analysis of the MRI. There's a question of whether or not there's degenerative changes or aggravation of a pre-existing symptomatic degenerative disease of the cervical spine. So this, to me, it looks like this could just be our ordinary, I don't want to say ordinary, but what we see very often is a battle of the experts.
Your Honor, there's a lot to unpack there, and I'm going to try to address each point that you raised. If I miss one, please let me know. First, it does not matter how the question reaches this court. The evidence is the evidence. If the evidence submitted is objective proof of serious injury, then whether the evidence reaches this court on defendant's affirmative motion or whether it reaches on a cross motion does not matter. Evidence of serious injury is evidence of serious injury. This court held in Rook versus Wood, Justices Del Conte and Justice Hanna were both on that panel. In that case, Rook versus Wood decided just last year, this court held that the exact same defense medical proof that was submitted by the defendant in this case constitutes objective proof of serious injury. What is that proof? That proof is a diagnosis from a defense medical examiner that plaintiff sustained a causally related muscle strain and quantitative assessment of loss of range of motion. That constitutes objective proof of serious injury. That's the only proof that has been submitted to this court and to the lower court on both defendant's affirmative motion and in opposition to plaintiff's motion. If defendant's proof is objective proof of serious injury and Dr. Capicato's proof is objective proof of serious injury, where in the record is there proof that Ms. Kessler did not sustain a serious injury? That was the question that I opened my argument with today. Now, touching on pre-existing, Your Honor, Where in this record is there any opinion whatsoever that Ms. Kessler's injuries to her cervical spine or loss of range of motion in her cervical spine are related to a pre-existing condition? Dr. Letty does not give that opinion. Dr. Capicato does not give that opinion. In fact, Dr. Capicato categorically rejects that idea. Dr. Capicato states that the injury and the loss of range of motion is not related to a pre-existing condition. Ms. Kessler was not in pain.
Hang on. But Justice Montour, I believe, is pointing out to you that the range of motion here isn't your typical range of motion. It's not by measurement. He's saying it's based on her subjective talking about her pain. And so I believe that's what Justice Montour was alluding to. So, and that's in the record. So what's your direct response to that?
I was getting to that, Your Honor. Thank you.
Okay, well, why don't you get to it now?
Yeah, thank you. I will. What we have under the serious injury law is a quantitative analysis. That quantitative analysis is range of motion. Of course, whenever range of motion is measured, there is a subjective component to it, but it is an objective test. This court, the Court of Appeals, every appellate court in this state has determined that range of motion is an objective test.
Right, but what they actually measure how far somebody can move their arm. That's what we're talking about. Okay. And I think in this record, what he's saying is that's not what's being referred to. This is more just her saying, oh, I have pain at this level by moving by a certain amount. I think that's the difference.
Well, range of motion is always restricted by pain. That's the basis of a range of motion test.
It can be, yes, that's true. It can be, but it also can be you just physically cannot move your arm by a certain amount.
Well, that would be under maybe the loss of use category, Your Honor. This is significant limitation. This is not loss of use.
No, it'd be both. Be either.
Well, I don't necessarily disagree with you that it could be either, but what you are referring to is the inability to raise or lower or turn a body part. That would be loss of use. What we have here is a significant limitation of use case. And whenever range of motion is tested, it is an objective test based upon subjective complaints of pain.
And
that has been held.
Measured, right? We have measurements. We have Dr. Letty giving actual measurements, showing objective limitations in the plane.
Correct.
And that's the basis that you want us to say. Dr. Letty gives us the data, which to find significant limitation of use. And so does Dr. Capicato. So where's the question? That your argument?
That's exactly it, Your Honor. And that is what this court determined just last year in Rook versus Wood, that the exact defense medical proof submitted in this case is objective proof of serious injury. So if defense proof is objective proof of serious injury, plaintiff's proof is objective proof of serious injury, then Ms. Kessler sustained a serious injury as a matter of law to her cervical spine under the significant limitation of use category. I want to get back to another thing that Justice Montour raised about Dr. Letty's opinion that the injuries had resolved. This case does not come to this court under permanent consequential limitation. It comes under significant limitation of use. A limitation does not need to be permanent to qualify under significant limitation of use. That is well held in this court and other courts across the state. Another point raised by Justice Montour was on the expert point. And Justice Montour, I think, said that this isn't conflicting experts. Well, I don't disagree. There are things that Dr. Letty and Dr. Capicato disagree about. But the things that Dr. Letty and Dr. Capicato disagree about are irrelevant. What they do agree about is that there is a causally related injury to the cervical spine, and both the report of Dr. Letty and the affirmation of Dr. Capicato confirm that there is loss of range of motion, that Ms. Kessler suffered from and still suffers from loss of range of motion in her cervical spine. That's the proof that's before this court.
Let me get back to what Justice Montour was talking about. So if your argument is that she suffered a significant limitation of use that's documented by the defense expert, correct? Okay, and Justice Montour pointed out, but the defense expert also said it was resolved. But your argument would be that, so from the time, at least from the test until the time the defense expert says it's resolved, you should be entitled to summary judgment based on that particular time frame.
I think we have to be careful here on what it says in Dr. Letty's report. Dr. Letty says that the cervical sprain resolved. Dr. Letty did not say that the loss of range of motion resolved. How could he possibly say that if he measured loss of range of motion in July 2024, 2.5 years after this motor vehicle accident? That's not what he said.
But what you're saying, he was that specific? That's in the record.
Yes, Dr. Letty states that the sprains had resolved. But as I said before, an injury need not be permanent to qualify under significant limitation of use.
Right. Okay, go ahead.
I think I touched on most of my points there. I think I just want to drill home that there is no evidence in this record that Ms. Kessler did not sustain a serious injury. The only evidence in this record is that Ms. Kessler sustained a serious injury to her cervical spine under the significant limitation of use category. The lower court's order should be modified and Ms. Kessler should be granted summary judgment on the issue of serious injury. Unless there are any other questions from the court, I'll rest on my briefs.
Thank you.
Good morning, and may it please the court, Richard Porter from Hagelin Spencer for respondents. It's our position that the Supreme Court correctly denied plaintiff's cross motion for summary judgment on the issue of serious injury based on the conflicting expert opinions in this case. Dr. Letty, who we were
Hearing counsel tell me and tell us that there, in some respects, the opinions are not conflicting. That in one very important respect, that they actually agree. And that's with regard to the significant limitation of use aspect. Okay, it's a non-permanent in nature injury, and it has been defined objectively by Dr. Letty to show that there is a limitation in the use of this person's spine or whatever. You know, he's saying that that means summary judgment on significant loss of use. We've got your guy saying it, their guy says it. Why is that case closed?
Well, I would disagree that that's Dr. Letty's ultimate conclusion, that the plaintiff sustained a significant limitation use of serious injury in this case.
You know what? I'm going to say that that's right. He probably didn't say those exact words.
Correct.
Okay. But what he did was supply objective evidence. He used the goniometer and he measured the limitations. And basically, you know, in his report, you know, he admits that he did all those, you know, and he comes out with percentages of loss of use. Okay, so no, he didn't say, I agree with Dr. Capicato, but he did give, like I said, objective evidence. Those measurements are not considered subjective evidence, though that by our law is considered objective evidence, you know.
Yes, Your Honor. And Dr. Letty elsewhere in his report in the opinion section, he also said that plaintiff had prior degenerative disc disease as evidenced in the cervical MRI that he reviewed. So he reviewed that film and said there's no evidence of traumatic injury on this film. He also reviewed plaintiff's prior medical records in which...
We're aware about it. We're really focused here on this range of motion argument. So why don't you address that? You heard what your opponent said.
And my point with respect to the range of motion is Dr. Letty, and we're entitled to every favorable inference in the procedural posture of this case. Dr. Letty, you can infer from his opinion that these range of motion limitations are due to pre-existing degenerative disc disease that was documented in the medical records that he reviewed. He reviewed plaintiff's prior medical records, which alluded to prior injuries and complaints of pain that she had to her cervical and lumbar spine prior to this accident. And so the inference from his report as it's with respect to the range of motion limitations is that they're due to these pre-existing issues that she had and were documented and don't have anything to do with the subject accident. And counsel stated in his argument that it doesn't matter how this question comes to the court. And I would just reiterate again, as Justice Montour said, it does matter how this question comes before this court. This is plaintiff's motion. What this court must decide is whether or not a question of fact exists in response to plaintiff's prima facie showing. And the Rook versus Wood that counsel cited to that dealt with whether or not a defendant had met their initial burden on summary judgment. What we're asking this court to decide is whether or not a question of fact exists to plaintiff's showing. And we argue that absolutely it does. And that's evidence in Dr. Letty's report, in his opinion, that this accident did not cause a significant limitation, serious injury, and as a result, plaintiff's motion should be denied.
Okay, thank you, counsel. Okay, next case for argument, case number 498, Sturk versus the state of New York. And counsel Demuse will be by virtual, and Mr. DeLuca, you're here.
Good morning, Your Honor. Yes, Stephen Lucia on behalf of.
Did I mispronounce your name?
Yeah, that's fine. I get so many other things. Trust me, it's fine. Anyway.
Can you need to wait till
Oh, I'm sorry.
Mr. Demuse is appearing? There we go.
Your Honors, can you hear me? I'm sorry, my picture is not appearing.
We can hear you. You can hear us?
Yes.
And you'll let us know whether you can hear counsel.
Right, I can so far, yeah.
Okay, awesome. Then if you don't have any objection to going without the camera, we'll continue.
Not at all.
Okay, now you can go.
Morning again, Your Honor. Stephen Lucia on behalf of the appellants Joy and Gilbert Sturk. Your Honors, I find it difficult to conceive a case where the state's liability is clear. You know, we have a situation where they maintained a dangerous condition on the canal for years. Their own documents contain language that says these bollards are dangerous conditions. They shouldn't be used unless there's a documented history of vehicle intrusions.
Counselor, sorry to interrupt you, but their position is at the time that the trail was constructed, they complied with the state of the yard and installing a bollard. It wasn't until after 2012 that we get some new guidance. That's their position.
Right, Judge, they would then have the obligation to make sure that their property is maintained in a safe condition. So, yeah, from 2012 to 2019, they have that time to go.
Right, that's your response, that somewhere in there, you've got to go and do a rehabilitation on your canal trail.
Absolutely. A property owner has the obligation to go and make sure their property is safe for users of the property, including the canal. You know, and clearly
There was no evidence of similar accidents at this particular location, were there?
not at this particular location, but there, as the record indicates, there is emails between the High Canal officials who are discussing this very situation and involving other bollards, where and the language itself anticipates that this is the type of injury that will happen. I mean, their own design guide says you have to anticipate that riders on bicycles may be riding in a line behind each other, and these bollards are a danger, and they could cause grievous or fatal injuries. And that's what happened here. I mean, the injuries, Ms. Sturk is paralyzed as a result of this accident. You know, and I don't know how you get around that they didn't have notice of this when it's discussed. The chief engineer of the canals is brought to the other employees' attention of these other accidents. If that's not noticed, I'm not sure what is. You know, the other thing is that the bollard is inherently dangerous. Our expert opined that under any circumstances, these things cannot be made safe. And that's evidenced by the nature of the injuries that occurred to Mrs. Sturk. You know, the other thing is that the cost to remedy this situation would be minimal. You know, the state had said, well, you know, we have to redesign, you know, akin to highway redesign. This is a bollard that sits in the ground. You can pull it out. I could go there and pull it right out, put it on the ground. As a matter of fact, there's testimony in the record that shows that this particular bollard was out of the ground for 2 weeks prior to the accident. And that there's also evidence that the witness testified that a different bollard was put in when it actually went back into this location. That there was a shorter bollard than prior to this person that his deposition testimonies in the record testified that he went by there many times and he saw the bollard, and the one they put back was higher than the one that was there.
Counselor, I'm a little concerned about some of the record testimony. Your client, I think that the state says that in theory, initially, or your client's theory was that the vegetation obscured the bollard. And now it seems that the argument here is that her husband obscured the bollard because they were traveling in tandem. And so was that argument made below?
Both arguments were made, because I think that they were made in conjunction. If you look at Joyce Sturck's testimony, she says as she approached, the vegetation was blowing from the side of the trail. She said there was a breeze and it was blowing, and that she's riding behind her husband. He swerves to miss the bollard, and she went straight into it.
Right.
So I don't think the two are exclusive.
I mean, you can't miss the bollard.
You could.
Unless it's obscured. That's the response here too from the state. This is open and obvious. How do you respond to this argument that this was an open and obvious danger, if it was a danger at all?
First off, I don't think it's open and obvious, but I respond to that in this way, that is a comparative negligence argument. That's what that is. Should she have seen what was there to be seen? I don't necessarily agree that it couldn't be seen. If you look at the pictures, that
doesn't negate the duty to maintain your property.
Does not negate the duty. That's absolutely correct, Your Honor. So, getting back to the mitigation point, as we pointed out in the record, the state formulated plans to remove the single post bollards in an area 15 miles away from where this accident occurred. I mean, it's conceivable that they didn't even know this bollard was there, but nonetheless, they still had the obligation to remedy that dangerous condition, in our opinion. Your Honors, that's all I have, and I'll rest on my brief for the remaining points.
Thank you, sir. Okay, Mr. Demuth, it's your turn.
Yes, thank you, Your Honors. May it please the court, Owen Demuth, on behalf of the respondent appellants, State of New York and the Canal Corporation. Your Honor, I want to begin by pointing out that throughout this appeal, or these appeals, the claimant has really mischaracterized defendant's argument. It's not only that the bollard is open and obvious. That's not all the analysis. It's also that it's not inherently dangerous in light of the surrounding circumstances. That's the standard to apply. And what that does is it requires the fact finder to ask, was there something about this bollard, about this particular bollard or its surroundings that obscured it or created optical confusion that would have prevented claimant from readily observing it? If the answer is no, we believe that is the answer here, then there's no comparative fault to allocate. The state's not liable. And here the state established on its motion both the open, obvious, and non-dangerous.
But I think we're misstating the open and obvious. That's not what it is. It's more, I think counsel is correct on his take on it. It goes more to damages. If it's an unreasonably safe condition, it doesn't matter if it's open and obvious.
Right. I agree with you. No, but that's what I'm trying to draw that distinction here, that this is not this bollard without more. Like, right. I agree with you, Your Honor. If we were dealing with a landmine, I'm using extreme circumstances, examples, or a bear trap, it would not be enough for the state to simply say it's open and obvious. But apart from the open and obvious, which is part of the overall analysis, it's the fact that it's not inherently dangerous, just as the First Department held in the Puma case, which is the only other bollard case.
Counselor, it's difficult. We can't see you, but their response, I think the plaintiff's response to whether it's inherently dangerous is the 2012 guidelines that indicate that bollards are at least dangerous. They shouldn't be used unless they're necessary, and they're dangerous in a way because they're obscured when riders are traveling in tandem.
Your Honor, two reasons why those guidelines do not carry their burden on summary judgment. The first, I want to get to, and this kind of goes to both motions. Yes, they have argued throughout the appeal that Mrs. Sturck was her vision of the bollard was blocked by her husband riding in front of her. That is exactly the opposite of what the only trial evidence shows. On pages 719 to 721, which was Mrs. Sturck's deposition, she was asked, did Mr. Sturck impair your vision on that path in any way? She said no. Now they are taking a different tack, but it's simply not supported anywhere in the evidence. Regarding the 2012 guidelines, that also doesn't, this was part of the questioning at the beginning of counsel's presentation. It's the 1991 guidelines, because there's no dispute that there's been no significant reconstruction or rehabilitation of this area of the trail after it was built in 1997. The relevant governing guidelines are 1991, and those guidelines did not discourage the use of bollards in any way. So again, there's no duty to upgrade an existing facility simply because new guidelines, the 2012 guidelines, have been issued. And there isn't a duty to remove the bollard. They also refer to these 2013 plans, which I think are even more far afield from carrying their burden. Those are on pages 517 to 533, regarding a project regarding not just bollard removal, but significant enhancements to the trail some 15 miles away from this part of from where this bollard and this part of the trail was. Now, those shop drawings, and we don't know anything about the details of this project except from looking at the shop drawings, they show that there are many reasons for this project. There was trail realignment, there are rehabilitation of the trail services, there's grading of the shoulders, and there's repair of the canal banks. So, but yes, it does have a note providing for removal of bollards, maybe to allow for the resurfacing to happen. We're not sure. We don't know. But if that was part of claimant's affirmative motion, it wasn't anything to do with ours. It was their burden to establish, to provide more evidence to this effect, to show that we should have known that the bollard was dangerous. And it didn't provide constructive notice. Constructive notice must be specific to the actual allegedly dangerous condition. We can't point to a bollard or vague, again, they point to, with almost nothing else in the record, evidence that somewhere along the line, somewhere, two other people struck a bollard. That is not enough. There must be evidence that this specific to this actual dangerous condition. Was there something about this bollard, in other words, some defect, something that obscured it from claimant's view, or something in the background that distracted or confused it? And I think this is where we circle back to the pictures. I think if you look at the pictures that were taken, the only ones taken by a disinterested witness were taken on the day of the accident, about an hour and a half after it happened, by Sergeant Dresser of the Macedon Police Department. The one picture, there's a number of pictures that support our case, but the one we feel is the clearest and shows this bollard plain as day on page 812 of the record. And certainly the court can draw its own conclusions from these photos, as the Court of Appeals did in Tagle, as the First Department did in Puma. This shows plain as day a 5-foot post covered on all sides by colorful tape with a spray painted white arrow on the ground in front of it. Vegetation on the trails, nothing that you could reasonably say was obscuring this bollard. In fact, it was clearly visible even from the intersection that claimant had crossed some 50 feet away. Again, these are the surrounding circumstances where the court uses to determine whether something is inherently dangerous. It was a clear sunny day. She acknowledged that her view was not blocked. Contrary to what you're hearing now, she said expressly that she was not blocked by Mr. Sturck riding in front of her. And she knew all about this bollard because she had passed it while riding in the other direction that very same day, that very same trip. And she passed it on many previous trips. And as Mr. Sturck, claimant's husband, testified, there was sufficient room to safely maneuver around the bollard. And given all these circumstances, this bollard is not inherently dangerous. It's no different than any of the other everyday objects that legions of cases have dismissed complaints arguing otherwise. This is just like the steps in those cases, trash receptacles, signs, other types of posts, or the bollard in Puma. And so I think the state has clearly established its right summary judgment here.
Okay, thank you, Mr. Denman.
Thank you.
Next for argument, case number 500, the matter of William DeLine. Good morning, Mr. Sarando.
Good morning, Your Honor. May it please the court, John Sarando for the respondents. I realize that the opponent has submitted, but I'd just like to point out that the appellants had no objections to the probate of the will And once the will was probated, they lacked standing to compel an accounting since they weren't beneficiaries of the trust, and we ask that the order be affirmed.
Any questions? Thank you very much.
Thank you.
Next, case number 501, the matter of Michael Simmons and Marsha Simmons Krim. Morning, counsel.
Morning, Your Honors. Jared Smith for the appellant. Your Honors, I'd just like to say that discretion is very dangerous when it denies fundamental rights, and in this case, that's the whole point of this appeal. My client was not given the opportunity to have a full and fair hearing. It seems as though the lower court did not recognize that there were genuine issues of material fact that needed to be discussed, and basically an evidentiary hearing ordered and discovery ordered in the case. For some reason, again, when you have, it is my understanding, judges judge the law, juries judge the facts. In this case, it would have been a judge judging the facts, therefore a hearing should have been granted. Excuse me. Also,
it appears the court was somewhat concerned about all of the corpus of the estate, going away. The money that it seemed to have cost to litigate seems to be a lot in relation to what's left, and the court maybe shortcut you somewhat.
I would say so, because right now, currently, and this is not before the court, the corpus is gone, and it's not because of my client. And that's being litigated.
Is it because it was administered? As I read the trust, upon the death of Pearl Simmons, the trust is to be divided among the children.
It was not.
It has not been administered.
It has not.
There's still litigation.
There's litigation going down, actually litigation before one Supreme Court justice and another in surrogate's court's been returned.
Did it get distributed because there's nothing left?
Do I have time?
You can just tell me I'm off base on.
Yes. In our, so I represent in another matter, the three brothers, one including Mark Simmons. We believe, well, we don't believe, the corpus of the trust was, in our view, illegally sold off to a nephew and then to his company, and then he got something from the Board of Regents opening up some public corporation to take care of it. But my clients have seen no money, no income, no nothing. And in this case, Pearl Simmons received no benefit from that trust. And what Mark Simmons was trying to do was to balance the scales. And when he became sole trustee, he was giving her what was due her, and it was income. It was not the corpus of the trust.
And that's it was 3 distributions of $1,000 went to mom.
Correct.
And that's what's at issue here.
I believe
that, and the $14,000 that he says went to his counsel.
Yes, Judge.
Okay.
And under the trust, like, what's good for the goose is good for the gander. None of the respondents' attorney's fees were paid out of their pocket. They took it out of the trust.
Okay.
So this is I'm arguing from a procedural standpoint that this should be returned. That I'm also fighting for Mark Simmons's reputation. He did not commit misconduct.
As I understand, your response is there was an application to the surrogate to have your client removed. Your client responded to that application, I think, with a cross petition, but he also had an affidavit where your position refuted all those factual allegations, and the surrogate should have given you a hearing.
Yes.
And you didn't get the hearing.
Didn't get the hearing. Well, I was not the attorney as well on that matter,
Your
but
client.
yes.
When I say you, your client.
Yes.
Get the hearing. That's what you're asking for, a
Yes.
hearing on the petition.
Yes. I think the lower court, the judge missed the boat on it. That there was, I don't know how to, well, it's pretty clear to me. Again, facts are judged by juries. In this case, it wouldn't have been done by a jury. She would have been wearing a dual hat, one of fact finder and one of judging the law. And on the papers, it was dismissed right out of the gate. And if and I want to point this out, if she relied on Michael Simmons's affidavit alone, because he claims he's this super accountant and he did an accounting of everything, he's a party. You need to have those people in front of you to attest to credibility, to allow the other side to bring forth an expert to counter what they're accounting. None of that was done. And I think the Surrogates Court Act is supposed to be a proponent of bringing together all the facts, all the circumstances to make a complete record. There was no complete record in this. It was just, we're done. We're going to do it on the papers. Thank you.
We understand. Thank you. Mr. Bruno?
May it please the court, Alfred P. Bruno, Westfall Law, for the respondents. Just want to clarify some things that are clarified in the brief. Your honors, there was a motion and a hearing back in summer of 2023 when the Surrogates Court reversed the order on August 22nd, 2023, dismissed Pearl's petition, restored my clients as trustees, and ordered Mark and his brothers, Kevin and Brian, to cease and desist of interference regarding the lease opposing counsel as referred to. The SCPA, or Surrogates Court Procedure Act, Section 719, does allow Surrogates Court discretion once that facts and evidence of misconduct have come out.
But there's new facts that were alleged in the petition. As I understand, the basis for your client's request to remove Mark is that he gave his mother $3,000 and he took about $14,000 out to pay his counsel. That's his response to the $14,000 dispersion. That's what was at issue in your petition, correct?
Yes, your honor. There were three separate $1,000.
And he put in an affidavit challenging the claims that those actions were misappropriations or inconsistent with the trust provisions.
Yes, your honor. My clients put forth affidavits. Also, there were motions in a hearing that day before the Surrogates Court, and in the Surrogates Court's discretion, there was no hearing because the misconduct was so egregious in the eyes of that court. He or she, it didn't deem it necessary. And I think that to distract with a Supreme Court matter that's going on right now and to make the statements opposing counsel has, I asked the court to dig into the facts a little bit because opposing counsel's brief on behalf of Mark Simmons is devoid of any facts, legal analysis, or case law. These are conclusory statements and another bite at the apple and an unmeritorious appeal in order to get this court to overrule that and put it back to Surrogates Court. This has all been done and heard. This is absurd, quite honestly. Mark Simmons' excuse for that $14,000, $421 check doesn't make any sense. It's completely nonsensical. Oh, I was going to pay my attorney, but I think I took it out. But it didn't go to an attorney. It went to his personal account. I mean, there was clear misconduct here by Mark Simmons as sole trustee. And in the Surrogate Court's infinite wisdom, heard the testimony of my clients, examine the facts in the case law, and we have the SCPA, Section 719. That is the Surrogate Court's discretion. To come back later after this has all been argued and say, oh, the other attorney should have done that, is of no moment. We have a brief that is devoid of any real arguments. The Surrogates Court did not abuse its discretion in removing Mark as a trustee without an evidentiary hearing under SCPA 719. The facts in this case are not disputed. Conflicting inferences may not be drawn from those facts, and there are no established mitigating facts by opposing counsel in his brief. Again, just conclusory statements. Because Mark did not brief the issue of whether the Surrogates Court properly dismissed his cross petition, he has also effectively abandoned that issue under well-established New York case law. We believe our brief is very tightly worded, argued, and the correct decision was made by the Surrogates Court. This needs to end. My clients have been harassed by their brother Mark for a long time. This has been 2 years to get here, and we're hoping that the appellate court sees through that in the smoke and mirrors and really looks at the arguments put forth here in our brief.
Thank you, counsel.
Thank you.
Thank you.
Okay, and the last case this morning for argument, the matter of Nathan Tripodi versus New York State Department of Correction. Counsel?
Good afternoon, Your Honors. Alexander Prieto for Nathan Tripodi. Since this is the last case for the day, I'll try to get right to the point. This case presents a single question of law. It's a question of first impression about a newly enacted statute, whether there's a right to appeal from a city court's final determination in a matter under subdivision 4A of Executive Law 259I. And since the right to appeal is generally statutory, the first place to look in answering that question is the relevant statutes. And there's two of them. There's subdivision 4A itself, the provision that authorized the proceeding here, and there is uniform.
Let's start there if I could, counsel,
Yeah.
because it's a very interesting issue. As I read your brief, your position is what happens in city court has to be either an action or a special proceeding.
Yes, I mean, on the civil side, that's all there is.
That's what this is. It has to be an action or special proceeding, and because it is, there's a judgment, and then your client has the right to appeal that judgment under the Uniform City Court Act.
That's it in a nutshell.
That's it in a nutshell. The enabling statute, though, this is where I want to get at. The enabling statute, called 4A, doesn't call this thing that happens in city court a special proceeding or an action. It calls it an appeal. Correct?
That's the word it uses.
And it even uses appellate language. 4AC, the appeal shall be perfected. And there's language in there about filing a notice of appeal in the same way that you'd file a notice of appeal to get to our court. What I'm not seeing in the statute is language about a complaint, a petition, or any other initiating document that would create a proceeding that would otherwise be appealable under the statute. You agree with me there?
Well, I agree it doesn't talk about a complaint or a petition. I don't agree if what you're saying is that there needs to be that for this to be considered a special proceeding.
So your reading of this statute is that this appeal, this purely appellate process that happens in city court or in county court or wherever you originate this appeal is a special proceeding.
It has to be considered a special proceeding, yes.
Counselor, let's go back even further. Okay. How does this affect your client right now? What's his status? Wasn't his maximum release date May of 2025?
He is now released.
Okay.
He's finished this particular sentence.
Right. Okay.
But the respondents have not said it's moot. No one said this case is moot.
Well, we can say it's moot.
And if the court is going to consider that, I'd like the opportunity to brief that issue. But my initial response on that is there are two ways that the court should still either decide that this is not moot or else apply and accept it.
Into the moot doctrine is the likelihood this may happen again.
And it has happened again. I mean, it's not in this record here, but I can represent to the court that there have been many after this case. There were many, I know of at least, I think, 4 or more that have happened just in this county.
But it's not just that it can happen again. It's got to be that it can't be reached.
Well,
somehow that it wouldn't be appealable. So if somebody chooses not to appeal while it's right for appeal, they didn't appeal. But just, because you're waiting.
He didn't wait. My client didn't wait, Your Honor.
Are you arguing that this could not be reached? And that's why there's three prongs of the mootness, the exception of mootness. It's just not that it can happen again. That's only one part of it.
Well, I don't think it's moot, and I'll get to that. But I do want to, before we get off on that direction, I do want to say that I don't think this case is moot because the fact that he has been found as a parole violator, that follows him around. He gets to contest that, even though liberty is no longer an issue. If he gets back before a court and he's gonna have a bail hearing, it's, well, look, he violated parole once. That's a factor you can hold against him. It can be held against him in a lot of cases, so it's not moot. But then we get capable of repetition and evading review. And it will evade review, just like if you were to say it was moot. If you say this one's moot, if the court says this one's moot, then it's probably going to say every other one that comes before it is moot, because most of these cases, they involve a hold, was what the department calls it, or a reincarceration of about like
Usually it's 6 months, a year. That's the average
In your
range
case,
of
it
it.
was 2 years, right?
Your Honor, I don't recall, but if that's what's in the record, I believe it was in that range.
But I think this court has said on parole violators that is something that would go against mootness. Your point that you just made.
Yes. So, what I'm saying is I've seen, after this case, every time someone tried to get from a city court to a county court in one of these, it's been no analysis, citation of this case, dismissed, no jurisdiction. So this is something that is coming up. It's a new statute. It's something, the department needs to know too. We need to know whether there is a right to appeal here. So that's my response on mootness, but I would like to go back to Justice Del Conte's question about the language of the statute, the appeal, because it does say appeal. If it said special proceeding, I don't think maybe we wouldn't even be here. But it calls it an appeal, but that doesn't mean that when we're looking at this, we look at it as an appeal in the strict sense of a case where you have a court reviewing the work of another court within the same judicial system. That's what an appeal is in a narrower sense. This is, more strictly speaking, what I would characterize as judicial review. A court is called on to review the work of an executive branch administrative agency. And that happens all the time. It doesn't quite happen with this exact procedure, but it happens very frequently. The most common example is the Article 78 proceeding, and that is considered a special proceeding. It's considered a special proceeding that ends in a judgment. Respondents have also analogized to some of these rare cases where most often it's in a third department, but sometimes it happens in this department as well, where a case of, and it's sometimes characterized as an appeal, a review of something that an administrative agency done is heard in the first instance in this court. And those are all special proceedings. We look at
that's true, but those are all initiated with a petition and a notice of petition or some other document, not a notice of appeal. And I think one of your strongest arguments here is, but we have to look to the Constitution of what's the jurisdiction of city court, right? Because I think that's where you come back, that city court has no appellate jurisdiction.
That's right.
And so how could they sit as an appellate court?
They don't, and they can't.
They have that's your response to this. It has to be a special proceeding because they don't have appellate jurisdiction.
They don't have appellate jurisdiction for the case. I mean, and city court aside, for a case to get into this state's court system, not the executive branch, the judicial branch, the judicial system, for a case to get in there, it has to begin life at some point. If it's a civil case and not a criminal prosecution, it begins life as an action or a special proceeding. Those are the only things there are. If the legislature had not intended for this to be an action proceeding, if they meant to make this an appeal, not an action or proceeding, they would have done something unconstitutional. They would have created something where the city court is hearing something that it can't under the Constitution hear. And courts, when they're interpreting a statute, of course, we always try to avoid that result. The legislator wanted these cases to go into city court. We don't want to say that's unconstitutional if it's a close question and it can be avoided. And so this statute is not unconstitutional. No one suggested it is, but to make sure that it isn't, we have to interpret this as being an action or proceeding. There's really nothing else that it can be.
Except if it fits within Article 6, Section 30, that says the legislature can modify the jurisdiction of the courts. That would be the response to that if we were to reach this on the merits. This is a very challenging question here when the issue may be moot as it relates to your client.
Well, to respond about this idea of modifying the jurisdiction of the court, it can do that, but it's got to do it in a way consistent with the Constitution. And if they're doing something as big as we're modifying the jurisdiction of the city court, I mean, one would expect there's going to be language, something straightforward. We are changing the jurisdiction of the city court so that it can hear something other than an action or proceeding. There's nothing like that there. So to me, this really is a case that is resolved by straightforward application of statutory interpretation principles. You know, we look at the language the legislature used and we give it its ordinary meaning. The Uniform City Court Act 1702, which says the judgment is appealable, that was on the books. It's been on the books for decades. It's been there. The legislature has never indicated there was a problem with it. It's been applied consistently, basically in any case in city court, and where, unless there's a contrary specific indication. If the legislature didn't want it to apply, all they needed to do, they could have said it doesn't apply. They could have said we're creating an exemption to it. They didn't. If that's what they wanted, that's what they would have done. That's a standard way that courts look at a statute when they're interpreting it. So I just want to, can I get a second to collect my thoughts unless the court has any more questions? Yeah, I believe that I've hit everything that I intended to address, but I will, you know, as far as there's a mootness point, it's sort of, I mean, they had a footnote in it. The respondents did not think this was moot either. So I didn't address it, but I would like to have the opportunity to address that in writing as well. Thank you.
You're gonna do a closed argument?
Yes.
Okay, do it quick, okay?
Okay, thank you, Your Honor.
Just briefly on the mootness, we just, in a footnote, we noted that there is kind of an open question about whether when someone is completely off parole, whether or not the case would go moot, the challenge to a revocation would go moot. There's language in People versus Beyond, a Court of Appeals case, which suggests, it's kind of indicta, that it might not go moot. There's a Supreme Court case called Spencer versus Kemna, that's federal Article 3 jurisdiction where it would go moot. Our position is that even if you thought this was moot, it would warrant exception to the mootness doctrine because it is so important. It is a novel issue, and it so thus far evaded judicial review.
Can agree on that issue that it's not moot.
I think we both would like a rule. Yes, we think the court has jurisdiction to
The
rule.
Court of Appeals is saying it's not in federal. Which one do you think should be following?
I think it's an open question because I think that what's in the Court of Appeals could be read as dicta. It wasn't really directly taken on, litigated in that case, as far as I can see. So, you know,
I think this court has said on occasion that about if somebody's on parole, that it wouldn't be, that was found to have violated parole, that would be not moot.
But then at this point, we wonder what we can do for, what kind of relief could we give, the petitioner here? And that's really nothing. We've passed all the timeframes that anything that this court would do could benefit him. And that seems to shout a little bit of mootness.
right. And I don't think the court necessarily needs to tackle the issue directly. That's obviously up to this court, because I think it would qualify, even if you thought it was moot, I think it would qualify as an exception to the mootness doctrine for all the factors that go into considering whether something warrants an exception.
But when you do your post-trial submissions that you're both going to do quickly, as Justice Minister, suggested, maybe you could suggest what type of remedy, if how are we supposed to, formulate that? Just make a proclamation and say, it doesn't affect him, but this.
Well, I guess that's what would normally occur if you're applying an exception to the mootness doctrine, because it's moot, you can't afford a party relief, but you're finding that the issue is of such importance that it's important to declare what the law is. That's the very nature of it, I guess. So getting back to whether or not this is an action or a special proceeding or something else, and it's not a special proceeding. We know that just from, you can take an appeal from a judgment in city court from a final judgment in a special proceeding. They're not claiming it's an action. They're claiming it's a special proceeding. The City Court Act under Section 400 lays out exactly how you commence a special proceeding in city court. You file an order show cause or notice of petition and a petition. You serve a party to get jurisdiction over them with a petition or the order show cause and notice of petition. That is not what is happening
We
in this
know
case.
that's not what happened here, but on the face of the statute, you're not making the argument that the legislature violated the Constitution in enacting this procedure.
Absolutely not.
By essentially giving city court appellate jurisdiction.
No, and what I would like to point the court to, because I think it's highly relevant, is workers' comp law section 23 and labor law section 624. And those are both examples of where the legislature has carved out an administrative role that somebody files a notice of appeal with the relevant board, and the appellate division, it's in the third department, I think all those cases are. The third department acts as an administrative body. And when they decide the case, they don't issue a judgment. They either affirm the determination or reverse the determination of the agency. But those cases are and this is similar to this case where the court is acting as a quasi-administrative, quasi-judicial body. And in those cases where they lay out the procedure specifically, what they do is they also say, if you want to further appeal, you can appeal to the Court of Appeals. There's express authorization for a further direct appeal. Those are cases where the courts have been designated to act as administrative bodies over an agency. Usually it's for speed. They like in workman's comp cases or employment insurance cases. And even in this case where they want to be the litigant or the party to be able to get to the court quickly and have a resolution.
Well, counsel, following your analysis, because the city court's appellate court normally is the county court, right?
Correct.
So following your analysis, wouldn't they have an automatic appeal to the local county court?
Well, no.
Determinations?
Well, my point is that they don't have an automatic direct appeal.
No, but following your analysis, wouldn't that be logical that if the unprevailing party was not satisfied with the judgment of that city court judge or the determination of that city court judge, the review will go to the local county court?
If they had a right to direct appeal, but our position is they don't have a right to a direct appeal. It's not authorized by 4A, and it's not authorized by the statute of general applicability, Uniform City Court Act 1702(1A), which authorizes direct appeals from final judgments. A judgment can only arise in an action or a special proceeding. And my point, Your Honor, is that when the court is acting as kind of an administrative appeal body, as in the labor law cases and the workman compensation law cases, the court it's not an action or a special proceeding. It's neither. It's
Counselor, let me if I could, the petitioner's response to that is the Constitution doesn't allow city courts to sit in this quasi position. City court jurisdiction is limited to actions or proceedings. That's their reading of the Constitution. And so you're bound by that. How do you get around that argument?
Because this is a proceeding, and it's a civil judicial proceeding. Well, the Constitution references actions and proceedings. What Appellant here is trying to say, well, that means the same, that Appellant conflates the idea of civil judicial proceeding with a special proceeding, and they're different things. So when somebody brings an administrative appeal to say under the labor law, the workman's comp law, or makes a pistol permit application, those are civil judicial proceedings, and the court is acting as a quasi-administrative body, but they're not special proceedings. It's not you can challenge a pistol permit determination by bringing a special proceeding, but when a court sits as an administrative body, then that itself is not a special proceeding or an action. But it is a civil judicial proceeding. So what the Constitution is referring to is just as generic proceedings. It's not making a specific reference to special proceedings.
So in your view, there is no separate proceeding that could review the city court's determination. It's not a separate.
No, it's an open question, I think, whether or not Article 78 review would be
Would
available.
be available to the city court judge.
If you would have to bring, let's say you wanted to challenge, let's say you wanted to bring a 78 proceeding and you go to state court, right? And you bring an Article 78 state Supreme Court and you'd have to name the judge.
It does happen in pistol permits.
Absolutely. Absolutely.
78 against the county court judge.
It's not quite clear if that's what was intended here. But there's a lot of specific references. You know what? The absence of any direction is kind of one of the interesting things about this statute. There's a lot of specific references to the criminal procedure law about procedure and what you should do and what you take. There's a lot of specific references about what the standard of review is and the powers of the review in court. But obviously, there's nothing about a further appeal or nothing about another judicial challenge to review that, and it just doesn't answer that question. And I would just cite People versus Stevens, which is a court of appeals case where this came up in the context of a court determining a risk level determination in SORA cases, and they tried to do that through the criminal appeals, take it through the criminal appeal process, and the Court of Appeals said, no, this is not authorized to challenge the risk level determination under the criminal procedure law, and they said we don't really know where this would be authorized.
But we hear them all the time.
But we're not going to speculate. We're not going to I know the after that case, the law changed and it was specifically provided for that they could bring those challenges. But this is before that, the change in the law. And the Court of Appeals said there's no specific authority. It's People versus Stevens. I think it's 91 here, cited in my brief. And the court said, we're not really sure what procedure would apply, but we're not going to speculate. We'll leave it up to the legislature to figure out, or leave somebody else to bring a case, maybe an Article 78, to see if that flies. But those issues aren't in front of the court. All I know is that it's not a special proceeding that ends in a judgment. By definition, the Uniform City Court Act lays out how you commence a special proceeding under Section 400, and that's not this case.
Thank you very
Does the
much.
court has any other questions?
If we're all good, thank you.